Can we give you?
Court is now in session.
It is better than 10 guilty persons escape than that one innocent suffers. These words of 18th century English jurist William Blackstone resonate just as loudly today as they did back then in relation to the magnitude of the injustice created by imprisoning innocent people. But what do we know about the causes of wrongful convictions in South Africa, and what can be done to achieve justice for innocent people who are languishing behind bars? We took a tremendous interest in a case that took place in 2013. However, the planning and plotting happened back in 2009 already. David Villiers, the owner of MSA Model Management and Agency, was facing a life sentence for allegedly raping a minor, exposing his children to child pornography, sexual assaulting and defrauding some of them, including a business associate. The Renslys and David worked together from 2008 until mid-2009 when they had a fallout at an event in Rustenburg. It was there where David was promised that he would be taken out. Little did he know it would be where he would be removed from society forever. Before we start, let us first look at what is a wrongful conviction. A wrongful conviction occurs when a person is convicted of a crime they did not commit. Such convictions amount to a miscarriage of justice, although that term encompasses a far broader range of circumstances than just a wrongful conviction, including the absence of a fair trial and the admission of unfairly prejudicial evidence. We will show you how this happened to Mr. de Villiers and his family. We have to call out injustice. Here you will see how a person was wrongfully convicted. It was never a matter of removing a criminal from society. It was to make an example of a person to satisfy public opinions and pacify the one-sided fake media.
We want to give a big thanks to our investigators and research team for the hard work they have put in to comply and verify the information for this report. Warning: parental guidance must be observed. The information we will share with you is sensitive and descriptive. This case was public, and we cannot hide any of the names of people in this case. This information aims not to create any form of violence or be used unlawfully. This is the property of palaver. You can only use it for information and reference, nothing else. This video will support the report and give a visual perspective of the findings of the palaver report.
The background. David started his career in the modeling industry after Dominique and Nicole invited him to judge their modeling competitions. One thing led to the next, and soon they held events together. David later offered to develop a structure where models can compete in modeling as a recognized sport. Within 6 months, David met with the Director of Sports and Recreation, Kelly, where she gave him recognition for his efforts. David, alongside the Renslys, held events where models participated in Model Cup for points and were later invited to SA modeling for provincial and national colors. David decided to run that by himself with the agreement the Pro Image company does the photos and videos. Unfortunately, Dominique and his wife was unhappy, and wanted half of the fees of the takings of the events plus all the takings from the images and videos. That caused friction among many other irregularities. They had a fight, they parted ways, and that was where Dominique took it upon himself to approach models via an email to get dirt on David. Dominique and Dion took it on themselves to approach Carte Blanche to assist them in exposing David. In 2012, Carte Blanche approached David with a false pretense to interview him about the modeling industry. David gladly offered his time to be interviewed to discover it was all a trap. Chantel, the presenter, posed questions to him like how does it feel to rape young models and attacked him from all sides to get enough material to create a show where David will look guilty. A couple of Sundays later, a teaser was on primetime TV, where they claimed that they would expose a rapist, sex predator and serial sex offender. It was a devastating plot, and blow to David and his family. Carte Blanche took it a step further, they sent camera operators to his church, where David played in a production, Passion of the Christ. But, unfortunately, it was just not enough for them. Not much came for that, or as fast enough as they would have wanted, and pressured the police commissioner to arrest David. A couple of months later, the SAPs arrived with a search and seize warrant and arrested David. David then spent 11 months in jail before his bail was granted. Approximately a year later, the docket was handed over, and eventually, the case started after it was moved to the Johannesburg High Court in front of acting Judge Kasim Musa. David's legal counsel was Advocate Pinar with the instructing attorney Rion Lau. It took David months to work through the docket to prepare for his trial. David had 33 charges against him. It is essential to note it was not 33 people. Instead, it was a collection of multiple accounts from the same individuals. The media, on numerous occasions, said it was 33 accounts of rape or that it was 33 victims. That was false. Now, let's get into the trial. We will start with counts 1 and 2, then the main charge of rape and sexual grooming of a minor, and end off with the 8 charges of access of child pornography. You can download and read the report. The link is in the description.
The trial. The trial started in late 2013. The first 2 witnesses were his 2 kids, Michaela and Keegan. The charges. Starting with count 1. Exposure of pornography/child pornography to a child, contravention of Section 19a, read with Sections 1, 55, 58, 59 and 60 of the Criminal Law, Sexual Offenses and Related Matters, Amendment Act 32 of 2007 and further read with Sections 92, 94, 256, 261 and 281 of the Criminal Procedure Act 51 of 1977. In that upon and about the period March 2011 to March 2013 and at or near Kempton Park in the district of Kempton Park, the accused did unlawfully and intentionally expose Keegan de Villiers to child pornography/pornography. It is important to note that when Carte Blanche ran his story on primetime TV, the kid's mother took the kids to the Teddy Bear Clinic for assessment to establish if David had done anything to the kids. After 3 assessments, the Teddy Bear Clinic came to a conclusion. The assessor concluded on page 11, paragraph 4, that he was not exposed to sexual intercourse, and what he did see on the computer was, in fact, of girls posing, which was the editing of the photos and not sexual content. I am saying this again. He was not exposed to sexual intercourse, and what he did see on the computer was, in fact, of girls posing, which was the editing of the photos and not sexual content. You will learn from the judgment, how the court manipulated this statement. In point 8 of her conclusion, the assessor of the Teddy Bear Clinic comes to the following observations: no exposure to explicit pornography material was verbalized by the child. This evidence was the most crucial part of the state's case. According to the evidence, it is essential to note that this was not used by the state but handed in by David's counsel. The first witness that was called was Keegan. We will now go through his chief testimony. The transcript, state leading the witness. Advocate Arvina Persat, the state, is leading Keegan in his chief testimony. From here on we will refer to her as Persat.
Persat, and what work did your father do?
Keegan. He took pictures of girls.
Persat. Now Keegan, remember we consulted about this, and you informed me that these girls that your father was taking photographs of, you have seen. Do you remember that?
Keegan, yes.
Persat. Can you tell the court what you saw?
Keegan. Some girls were wearing bikinis, and I can remember one girl. She was very naked, and I could see her bum from the behind. From the side, I could see a part of her breast.
Footnote 1. First description according to the witness referring to what he observed during the shoot.
Persat. Can you tell the court what you saw?
Keegan. Some girls were wearing bikinis, and I can remember one girl. She was very naked, and I could see her bum from the behind. From the side, I could see a part of her breast.
Persat. Keegan, did you see this girl in person or did you see this girl anywhere else?
Keegan. I do not understand.
Barsat. Okay, where did you see this girl?
Keegan. In my father's room.
Barsat. Okay, what clothes did this girl have on?
Keegan. She just had some, a cover by the front private parts.
Barsat. Then Keegan, do you remember saying to the court that from the side that you could see her breast? Can you explain to the court what you mean by that?
Keegan. I saw a part of her breast from the side.
Footnote 2. State advocate intends to confirm the model's nudity. The witness cleared this up and said he only saw part of her breast. This does not confirm nudity. We searched on Google models in bikinis and models in swimwear, and it is expected that models in those shoots wear bikinis whose side or part of the breast is displayed, including a large part of the bum or bum cheeks. It is not uncommon or unfamiliar.
Barsat. And were there any other girls that you saw at your father's house that were dressed in that way?
Keegan. Yes.
Barsat. Explain to the court what you saw.
Keegan. I saw girls standing in a row, waiting for my father to take a picture.
Footnote 3. We looked at the intention and purpose of the place and the shoot mentioned above surroundings. Here the witness is telling the court that, while he was sitting and observing the shoot, his father and many other models were also watching the shoot. Again, this is common from a photography point of view. The accused did not do it in secret, nor was it done with unlawful intent.
Barsat. What clothes did they have on?
Keegan. Most of them were wearing bikinis, but very little, very small bikinis. I could see their bum because it looked to me as like they put their panty in between their bum.
Barsat. Keegan, just the last bit of what you explained, can you say it clearly into the microphone, please?
Keegan. I saw girls who put their panties in between their bum.
Barsat. Keegan, before we adjourned, you were describing the small bikinis to the court. Do you remember that? Barsat. Okay, Keegan, now you explain to the court the back of the arm, panties that were worn by these girls. Can you describe what you saw at the front?
Footnote 5. Here, the state advocate leads the witness with a false narrative that he testified or mentioned panties. The witness did not mention panties. It was clear he said small bikinis. This is misleading by the state.
Keegan. Yes, I can describe the front.
Barsat. Please describe it, Keegan.
Footnote 4. Here the witness is telling the court that those models who were waiting their turn to be photographed were wearing bikinis that to the witness looked small. I consider the child's age from the time the shoot took place to the time he gave his testimony. At the shoot, the witness was only 4 years of age. By the time he testified over 3 years later, he was just over 7 years of age. The witness is not verbalizing that his father was doing an illegal shoot. We are seeing from this that the witness was interested in his father's work, and that this particular shoot, which was a standard bikini shoot in the photography industry, was just that.
Keegan. In the front it is like a normal bikini, but at the back it was not. It was like a panty in between their bum.
Footnote 6. The state is trying to get the witness to imply that he could have seen the model's vagina. The witness cleared that up by again testifying that the model wore a regular bikini. He did not say that it was underwear. He said it was a normal bikini to this point, and we can confirm there is no explicit sexual content or wrongdoing by the accused.
Barsat. Now, are there any other girls that you saw the front of their panties?
Footnote 7. The state, for the second time, is telling the witness that he mentioned panties. There is a massive difference referring to a panty and a bikini. One is a model used to swim and move around in public, the other is private and a personal clothing item. The state advocate leads the questioning to the witness, and with that intention, the witness still does not imply that he saw any of the models in panties nor their private parts.
Keegan. No.
Sat. Okay then, Keegan. Earlier you told the court that there was one girl that you saw her breast. Do you remember that? Where you saw? Sorry, Keegan. Where you saw a part of her breast. Do you remember that?
Footnote 8. For the third time, the state advocate uses her questioning to imply that the accused exposed the witness to the models in an explicit manner. She immediately corrected herself and referred to the model's breast part of her breast. All the witness did was confirm that he did not see the model naked, he only saw what was sticking out from what was not covered by the bikini. We are still looking for a crime here, and only get that the witness did not see any model naked, nor in an explicit way. This is how any 7-year-old male child would have described models in a typical bikini shoot.
Keegan. Yes.
Sat. Can you estimate to the court, how old do you think that girl was?
Keegan. I think about 16 or 18.
Mr. Pinar, the defense advocate. My lord. Sorry, one must object to that question. He is not an expert on this.
Court? Miss Prasad?
Sat. That is true, my lord, but the witness did say that he saw the girl, which means he would be able to give you an idea. There is a difference between an 1-year-old, a 10-year-old, and a 20-year-old.
Footnote 9. We cannot agree with the state advocate here. The child saw the models when he was only 4 years old. Now he is testifying about a shoot 3 years later, and the state asked him a perception question that no child of that age can guess. This question is irresponsible with the intent to get a minor to assume and imply that the models the accused took photos of were minors. The intention of the state is clear. The court should not tolerate this kind of questioning.
Court. Opinion.
Sat. Yes. It is, I do agree, just the witness's opinion.
Court. Nothing can flow from it.
Sat. Yes, my lord.
Court. Okay, the court will allow it.
Sat. As the court pleases, my lord. My lord, he had already answered it. He said about 16 or 18 years. Was there anybody with you when you saw this girl?
Keegan. Yes.
Sat. Who was with you?
Keegan. My sister.
Sat. My lord, I need to clarify something. I was referring to this particular girl, but I think there is a misunderstanding between the intermediary and me because she put the witness girls, but I was referring to one particular girl. So, I want yes. Keegan, let us talk again about this girl that you said that you saw, a part of her breast, who you said to the court is probably about 16 or 18 years old. Do you remember that?
Keegan. Yes.
Sat. Was anybody with you when you saw that girl?
Keegan. Yes.
Sat. Who was with you?
Keegan. My sister.
Sat. And your sister's name is?
Keegan. Michaela.
Sat. Now, this girl that you were talking about, that you saw a part of her breasts, did she have anything covering her breasts?
Keegan. No.
Footnote 10. This question is widely speculative and leading. The witness already said he only saw part of the model's breast. He also already confirmed that the models were not naked, and to as an open-ended question is confusing to a child of that age and hard to follow. As we assess this from the outside, we have to try and think like a 7-year-old and how the question was constructed. The state is trying to prove that the witness saw models naked and explicitly. The question does not give much thought to it. What kind of cover is the state advocate referring to? She does not ask the witness directly if she had a bikini top on. A cover could be anything. A bikini top is exactly what it is. And the child witness did already testify that she had a bikini top on as he could only see part of her breast.
Parsat. Okay, Keegan. And then Keegan, is there anything that you watched on your dad's computer that you wish to tell the court about?
Keegan. Yes.
Parsat. You can tell the court, Keegan.
Footnote 11. The state advocate asked the witness about what he saw on the accused computer, and he confirmed that all he saw were models like what he saw at the bikini shoot. The witness said that's all he saw. We also studied the teddy bear clinic reports. With the state's evidence, it is clear that this witness did not testify that he was exposed to any form of nudity/pornography or models explicitly or sexually.
Keegan. I saw a few girls almost the same as the previous girl that I was talking about, and some of them who were wearing clothes.
Parsat. And is that all that you saw?
Keegan. I do not think so, but I cannot remember.
Parsat. Keegan, you remember when we consulted, I said to you that there is another lawyer in court?
Footnote 12. The state concluded their questioning and has no proof that the witness was exposed to pornography beyond a reasonable doubt. We will now go back to point 41 of the judgment. The court states that the models were clad explicitly. This is not true. The observation from the court was not proven nor verbalized by the witness. Therefore, the court was not correct in his judgment, and the accused are not guilty of this charge.
Judge Musa, Keegan, page 110. Ref to point 41. On count 1, Keegan testified that he saw girls between the ages of 16–18 years old at the accused's residence, and they were dressed in such a manner that he was able to see part of their breasts and their bums. He saw a female whose breasts were not covered at the time when the accused was taking photographs of the girls. It is clear from his description that this witness was referring to the models wearing G-strings at the time when he viewed them being photographed by the accused. It was never put to this witness during cross-examination that the accused had never taken photographs of girls in G-strings in the presence of this witness. In addition, he disclosed to the assessor from the teddy bear clinic, whose report was handed in by consent as Exhibit AA, that he had seen people doing sex on the accused's computer and amplifying his response by stating when they touched each other's breasts. This evidence of the witness was never challenged during his cross-examination. This witness gave his evidence in a clear and satisfactory manner, having due regard to his relative youthfulness. It is clear that he would not have been able to provide such a description had he not observed the same. From the evidence led, it is clear that this witness viewed the buttocks of the girls and not the anus. However, he was exposed to girls clad in an explicit manner. In terms of the contravention of Section 19A of the Criminal Law Amendment Act 32 of 2007, the accused allowed Keegan access to his computer wherein he observed persons presenting themselves in an explicit manner, and that the depiction on the computer of the accused was conduct that was sexually suggestive and displayed a form of stimulation of a sexual nature of a person's breasts. Notes from the accused. Prasad kept asking Keegan questions about the girls and what they wore on the shoot day. Numerous times, Keegan explained that he saw girls in bikinis, but one particular girl he guessed was between 16 and 18 wearing a bikini, with her bikini bottom looking like a G-string. He further explained that he only saw part of her bum and the side of her breast. Prasad asked Keegan very specifically about what he saw on my computer, and Keegan said, I saw a few girls almost the same as the previous girl that I was talking about, and some of them who were wearing clothes. In the state's evidence that Prasad led, she did not establish any form explicitly related to the girls at the shoot. She also could not prove or demonstrate that what he saw on my computer was nudity, or any form of explicit material related to the charges. Prasad also did not tell Keegan what was written in the Teddy Bear Clinic report, that he did not see any naked girls doing sex, or even touching themselves.
Footnote 13. We have to agree with the accused observation here. The state advocate did not prove the charge of exposing the witness to pornography. One could have the wildest imagination, and it still does not constitute a crime. We must add that young and older women walk on beaches with their bums exposed, wearing bikinis that do not cover the entire bum. TV ads, magazines, and other advertising material demonstrate a similar shoot and environment as the witness testified about. There is and was not a crime committed here. If the court says that he did, he then is making almost every parent a criminal and potentially creating a new standard that can never be accepted, not in South Africa, nor any other part of the world. The transcript defense cross-examined the witness. Advocate Pinar, is the defense advocate referred to as Pinar?
Pinar. Now, you also said, before we come to this lady, that there were girls in bikinis at the house. Is that correct?
Keegan. Yes.
Pinar. And your father then took photographs of them. Is that correct?
Keegan. Yes.
Pinar. And do you know that these girls were models? That was the reason why your father took photos?
Keegan. Yes.
Footnote 14. The defense advocate asked an important question, which removes the question of lawfulness and intent. The witness was aware it was models, and he was aware that it was what his father did for a living. The state advocate said that the accused willingly and unlawfully exposed the witness to child pornography. This did not happen. The accused did a bikini shoot with numerous models while the witness and his sister were with him. The children were not there alone, and many other models saw what the witness saw. I failed to mention that we did not observe the state calling any other witnesses to verify that the bikini shoot was done explicitly as the court claimed he did. The duty to prove to the court that the accused is guilty of a crime is their responsibility, and the state did not prove this.
Pinar. Your father also took photographs of you, in a cowboy outfit. Can you remember that?
Keegan. Yes.
Pinar. Now, this girl that you told us that you saw, a part of her breast, did she have a bikini top on?
Keegan. I do not understand what you mean. I do not understand.
Court? What the advocate wants to know is that this girl that we are talking about, the girl we are talking about, currently is the one who you saw her breast partly exposed. Do you remember that?
Footnote 15. The state advocate asked the witness this question, and here the defense is correcting that. This is further proof that the witness never saw any model in any form of nudity or clad explicitly, as the court stated.
Keegan. Yes.
Court. Now, what the advocate wants to know is, when you saw this girl, did you see if she had a bikini top on? It means that, counsel? Are you meaning a bikini top on the breast?
Pinar. Yes.
Court? What counsel wants to know is that did you see if this girl had on a bikini top? If she was wearing a bikini top over her breast?
Keegan. No. Pinar. So, you know what a bikini top is? Is that correct? Keegan. Not really.
Pinar. Do you know what a bikini is then?
Keegan, a bikini is what girls wear. I do not know what to explain.
Pinar. Okay. Let me then ask you this. Did this girl, with her breast, where you saw part of her breast, did she have a bikini on? This girl that you saw part of her breast, did she have a bikini on?
Keegan. Not a bikini?
Footnote 15. The witness is confused, and unsure what a bikini is, clearly overwhelmed by the questioning. However, what is evident is that the witness did not say he saw her nipples of bare breasts. Instead, he only saw part of it, which means a bikini top must have covered it.
Pinar. What was she wearing?
Keegan. By the front private part, there was just a cover. Only by the front private parts?
Footnote 17. We have to point this out again, referring to our previous observation. The witness previously testified that the model had a bikini bottom on. Now, he is referring to only a cover. It is clear that this witness no longer is following the questioning and referring to something else. Even though he still cannot see or say he saw anything sexual, the witness is now becoming inconsistent. The witness is only 9, and he is telling and recalling stuff that happened when he was 6. It is not easy or even possible for any child to give a clear and accurate account of things at such a young age.
Can you remember at a time, about 3 years or 2 years ago that you were at the teddy bear clinic?
Keegan. Yes.
Pinar. And can you remember that you talked there to a lady?
Keegan. Yes.
Pinar. Now, she asked you questions about what happened there at your father's house, when you and your sister visited him. Is that correct?
Keegan. Yes.
Pinar. Now, you were not there only on once, or you were not there only on one occasion, you went back to see her again, and then you went back to talk to her again. So, it was 3 times that you went to talk to this lady. Can you remember that?
Keegan. No, I can only remember talking to her twice.
Pinar. Twice. Now, did you, or let me ask you this. Now this lady that you talked to, do you know what was her name?
Keegan. No.
Pinar. Now, when she asked you questions about what happened there at your dad's house, did you tell her about this lady that you saw part of her breasts and that she only had something covering her front part?
Keegan. Yes.
Pinar. Can you remember if she asked you if you saw any naked girls also in your father's house?
Keegan. Repeat the question, please.
Pinar. Can you remember if she asked you whether you have seen any naked girls, that is girls wearing nothing, in your father's house?
Keegan. Yes.
Pinar. Yes, and what did you say to her?
Keegan. I told her that I saw him. I saw her bum and part of her breasts.
Pinar. Now Keegan, I have got the notes that this lady wrote down when she asked you this question. Pinar. And the answer to this question, whether you had seen any naked girls in your father's house. She wrote down that say, no, not in your father's or in your mother's house.
Court? Sorry, Advocate Pinar. Can I just ask, is the witness going to be called?
Pinar. I believe so, my lord. I took it up with my learned friend and she says, she is going to call this witness. I will just repeat for you, ma'am, what the lady has written down to this question, whether he has seen any naked girls in his father's house? She wrote down, no, he has not seen any, not in his father's or his mother's house.
Keegan. I do not know what to say.
Court. So, what is the answer? I do not want to say.
Pinar. Now, this girl that you say that you saw, the one with the part of her breast, where in the house did you see her?
Keegan. In my father's room.
Pinar. Was she at the time when you saw her in the room, was she on the bed?
Keegan. Yes.
Pinar. Was she lying down?
Keegan. No.
Pinar. What was she doing?
Keegan. She was putting her hands on the wall and looking back.
Footnote 18. This question is crucial as it allows us to assess where the witness was in relation to the model's position. He said she was looking back, and this means the accused took photos from her with her back facing the accused and the witness. This also confirms what the witness could and could not see, along with the models waiting their turn.
Pinar. Now, when she had her hands against the wall, looking back, was her back then, the back side of her, is that what you then see? Pinar. Now Keegan, after you saw the lady at Teddy Bear Clinic, roughly about a year later, I know you do not know time but more or less a year later. Did the police come to you and talk to you about what happened there at your father's house?
Court? The question is, after you saw the lady at the Teddy Bear Clinic, plus minus 1 year later, did the South African Police Services, members of the SEPS come to you and speak to you about what you saw at your father's house?
Keegan. Yes.
Pinar. Did they talk to you?
Keegan. Yes.
Pinar. Did they write down what you were saying?
Keegan. Yes.
Pinar. Now, did you tell them about this lady?
Keegan. Yes.
Pinar. Now, when they wrote down, afterwards did they ask you to sign this statement or what they were writing down?
Keegan. Yes.
Pinar. Before they ask you to sign, did they read what you did they read back to you what you were saying to them?
Keegan. I cannot remember.
Court? Sorry Mr. Pina, appropriate for you to put to the witness, did they read back what they in fact wrote? Because I think where you're heading to is obviously, you want to put a statement to the witness and you were saying, did they read back what you in fact told them?
Pinar. Yes.
Court. But I suspect that you are heading to what is containing in the statement.
Pinar. Yes.
Court? And do you not think the more appropriate thing would be to say, did they read back what was written in the statement to you?
The witness has a problem down. If he could be given time.
Feel that you are doing a bad thing, but we will give you time to recompose.
Court? Are you in a position? The last question that the advocate asked you is, are you cross with your dad?
Keegan. No.
Footnote 19.
Pinar. Thank you, my lord.
Most of them were wearing bikinis but very Very little, very small bikinis. I could see their bum because it looked to me as like they put their panty in between their bum. Keegan did not say it was a G-string, and he would not have known what it was either. He made it clear that it looked like they put their panties between their bum. He also stated that an important fact here. The state produces no evidence, not the teddy bear clinic, that the witness was ever exposed to any nude models, nor verbalized that the models wore clothes of a sexual nature. The fact here is the opposite. The witness only experienced shoots with models in bikinis and regular casual clothes. Persat did not ask Keegan anything about this to clarify the matter. However, we did look at the entire report from the teddy bear clinic. It was evident that Keegan referred to naked girls as being dressed in bikinis, and the assessor concluded on page 11, paragraph 4, that he was not exposed to sexual intercourse, and what he did see on my computer was in fact of girls posing, which was the editing of the photos and not sexual content. Girls touching their breasts could have been a pose, with a bikini on, not naked, as he said on many occasions he did not see naked girls that one of the girls did on a photo I was editing. In point 8 of her conclusion, the assessor of the teddy bear clinic comes to the following observations. No exposure to explicit pornography material is verbalized by the child. Footnote 24. After carefully assessing the state evidence, including the witness's testimony, the cross-examination of the defense, and the teddy bear clinic report, Exhibit AA, this concludes that the state did not prove a crime. We cannot ignore teddy bear clinic's Esme the psychologist's findings, and the court failed to consider that report in its complete form. The court took the idea and perception of the state, not the witness, and convicted the accused of doing a regular photo shoot. I have to ask an obvious question the state failed to bring to the court's attention. The SAPs had access to all the accused computers, including hard drives, yet we do not see any supporting evidence of a shoot where the accused took photos of models in bikinis where their breasts were exposed. The state did also not provide a picture of models he took photos of that was dressed explicitly. The state did not prove that the accused exposed the witness to any model in any clothes being of a sexual nature or clad explicitly, as the court stated. Judge Musa used the Teddy Bear Clinic's report against me as evidence to find me guilty of the following charge. Count 1, Keegan de Villiers, exposure of child pornography, or pornography to a child, in that upon or about the period March 2011 to March 2013 and at or near Kempton Park in the district of Kempton Park, the accused did unlawfully and intentionally expose Keegan de Villiers to child pornography or pornography. Judge Musa used the Teddy Bear Clinic's report against me as evidence to find me guilty of the following charge. Count 1, Keegan de Villiers, exposure of child pornography, or pornography to a child, in that upon or about the period March 2011 to March 2013 and at or near Kempton Park in the district of Kempton Park, the accused did unlawfully and intentionally expose Keegan de Villiers to child pornography or pornography. Footnote 25. We do not believe that the accused ever exposed his kids to child pornography or pornography. This charge is a wildly speculative charge with no basis of intent or unlawfulness. The fact that the court ignored a vital part of the evidence is creating a question: on what did he base his judgment, if what the state had was nothing? It is clear that there was never any child pornography, or pornography established by the state, or by the Teddy Bear Clinic, yet the judge used one part of the report out of context. It was also clear that Judge Musa took upon himself to complete the work of the state to place a crime against me where the state failed to prove the charge against me. It is clear that Judge Musa only used particular parts of the Teddy Bear Clinic report of what was said by Keegan, but ignored the professional opinion of Esme and her observation, and the conclusion or the report in its totality. Pinar asked Keegan if he saw anything else on my computer, and Keegan said just what he saw at the shoot, so there was no need to dig deeper into it. Keegan also said that he saw it, not that I showed it to him or forced him to look at anything, so except for the fact that the Teddy Bear Clinic clearly said I never exposed Keegan to explicit pornographic material, I do not see how he can use that to say I intentionally exposed him to pornography, let alone child pornography. See address related to Keegan's evidence, transcript dated September 27, 2016, page 17. Palaver conclusion on findings. These were the first two charges. To think that the accused two kids were testifying against their father where the state alleged he exposed his children to child pornography or pornography. What was more worrying was the allegation that he did it with intent. We are of the opinion that both these charges were made against the accused to weaken his case. What could be worse in the public's eyes than a father who could do such a horrible thing to his own children? We could not find any evidence that the accused did expose his kids to pornography. The court made a huge mistake to use phrases in a report to find him guilty on these charges. The court did not consider the facts in the Teddy Bear Clinic report in its totality. After 3 different assessments with a professional child psychologist, the findings on both kids were that they had the perception that a bikini is bras and panties at a very young age. It was voiced in the report in the testimony of both kids that they were not exposed to any explicit clad, as the judge stated. It is out of context, misdirected, and not true. The accused children demonstrated that they loved their father. Both the kids were very young at the time of these shoots. Despite the effort from the state to come to the conclusion that the accused willingly and unlawfully with intent exposed the kids to pornography, it still does not meet the test to prove him guilty beyond a reasonable doubt. I have to agree with the accused that the state had no case and that the court convicted him even though there was insufficient evidence, if any at all, to convict him. David is not guilty and therefore wrongly convicted.